The shooting of Trayvon Martin, the Central Florida teenager now, and the big news this hour, the police chief who temporarily stepped aside last month over his department's handling of that shooting is resigning effective tonight. And the question is, will a potential Florida jury use this information as evidence? Back to the legal experts now. Randy Zellin is joining us now, criminal defense attorney and Fox News senior judicial analyst. Judge Andrew Napolitano is back as well. Randy, how would you use such a thing?
Well, I don't know. I've always thought from the beginning that this case was problematic from an evidentiary standpoint. Putting aside race, putting aside George Zimmerman, the defendant, the initial pursuit, to me, there was a second thing that went on. And right now, even we just saw, they don't know who the aggressor was. Therefore, I think the police chief actually acted rather diligently, reasonably, in really not knowing what to do. We don't know what input he got from the prosecution, and I think at some level he's being made to be a fall guy.
Look, obviously mistakes were made from the very beginning. Obviously, with hindsight, which is perfect, which is 20/20, he should have been charged at the time. He should have been restrained for some reason and some charge filed against him. But we now know that the prosecutors know a lot more than what the police knew at the time. But it is a very, very unusual case in which A shoots B with a gun, and A is permitted just to leave because of what A says at the scene. The police would want more information and would want to do more of an investigation before they decide, okay, you can go home.
This idea that we're on track now seems to make sense to most parties. There may have been mistakes in the very beginning, but now the process is working. But rallying for the man, I find it interesting, at least, given that this is a man who left his house with his weapon to pursue someone who he'd seen do nothing, and then he shot him and killed him. I don't know what happened in the middle there.
And that's exactly the point.
Of course, if he'd stayed in his house.
But unfortunately, the quirk in this law is that George Zimmerman, the defendant, could have been the initial aggressor. But at that point, if he does nothing more, and suddenly Trayvon Martin becomes the aggressor, and George Zimmerman reasonably believes that his life is in danger, according to this stand your ground law, he's got the right to use deadly force, which he used.
Yeah, it's an NRA law, and the NRA's even backing off that law a little bit, isn't it?
Well, the problem with the law is, as Randy pointed it out, that you can actually commence this whole thing yourself. You can become the initial aggressor, which is what the government is going to say Zimmerman was, and it's going to depend on what the evidence shows, and still claim the protection of the law. Most statutes that permit self-defense, permit you to use force or violence to defend yourself, do not permit you to do so when you started the whole thing. This statute, untested until now, does permit you to use force and violence even if you started the whole confrontation.
Is the word reasonable in there anywhere?
Yes.
Reasonable force?
Yes. I don't know if the word reasonable is in the statute. Right, right. But your belief that the other person is about to inflict deadly force on you must be a reasonable belief. So in order for the jury to take this defense into account at the time of his trial, Mr. Zimmerman must present them a basis upon which they can come to the same conclusion that he did. If he fails to present that basis, the court won't let the testimony